Welcome to the restrictions of disclosure lesson. Here I want to talk to you a little bit about the differences between the HIPAA and the 42 CFR Part 2. So there is a difference here as far as under Part 2, communications within the Part 2 program have to be on like a need-to-know basis. If there's a medical emergency where the patient can't consent, we need to document the disclosure, but you can disclose. You can report crimes or threats on Part 2 premises or against any personnel to law enforcement, but you need to limit the information. You can also report child abuse or neglect per state laws, and you can use it for research, subject to any conditions, and as a part of an audit by a program like a government or a payer or other lawful holder that's subject to the Part 2 conditions. There are a few limited exceptions when providers can make disclosures within a patient's written consent or without the patient's written consent. And this is going to include internal communications for medical emergencies, reporting of the child or elder abuse or neglect if it's required by state law, and it is in Georgia. Any reports of a crime on the program premises or against the program personnel, any qualified audits or evaluations of the program, for any research, qualified service organization agreements, so on and so forth. Or if there's a specific court order. So when Part 2 records are shared with the patient's consent, the records need to be accompanied by a notice that prohibits redisclosure so that the recipient knows that they can't redisclose that information except as permitted by Part 2. So I've included a sample notice prohibiting redisclosure in the lesson. So if you do disclose with the written consent, like I said, you need to include the notice. So this would be a sample notice. So you could put this at the bottom of the paper that you're disclosing. You can put this on a separate sheet of paper and put it at the front of the file, or if you're sending it through encrypted email, you would put this in I would just go ahead and put this in my subject line, my signature line on all of my emails. It would say something along the lines of, this information has been disclosed to you from records protected by federal confidentiality rules. The federal rules prohibit you from making any further disclosure of information in this record that identifies a patient as having or having had a substance use disorder, either directly by reference to publicly available information or through verification of such identification by another person, unless further disclosure is expressly permitted by the written consent of the individual whose information is being disclosed or otherwise permitted by 42 CFR Part 2. A general authorization for the release of medical or other information is not sufficient for this purpose. The federal rules restrict any use of the information to investigate or prosecute with regard to a crime any patient with a substance use disorder, except as provided at 2.12C5 and 2.65. Or you could just simply put 42 CFR Part 2 prohibits unauthorized disclosure of these records. That's just a basic line that you could put at the bottom of any documentation. We're talking about lawful holders because I said lawful holders are part of this and any agreements that we have with that. These lawful holders can disclose information to any of their contractors or subs or legal representatives just to carry out the purpose of the disclosure if they have a contract with the recipient and they agree to be bound by Part 2. So the lawful holder has to provide notice of redisclosure, protect the information, and report unauthorized uses, disclosures, or breaches. And they also have to keep a record of each disclosure in the file. So Part 2 generally requires a special court order before records can be shared with law enforcement or a court. A subpoena, a general court order, a search warrant, or an official request is not enough for law enforcement to access the client's treatment information. I'm going to say that one again. A subpoena is not enough. A general court order is not enough. A search warrant is not enough. Or an official request is not enough. So if you get a subpoena for any reason for a client's records, I've provided a sample letter that is a response to the subpoena for criminal cases, and it's located in the course, and it describes the requirement for a court order, and it can be a useful tool when we respond to law enforcement, because we don't want to be rude, but we also need to tell them no. So if they can't use any of this information to initiate a criminal proceeding against one of our clients. They can't initiate or substantiate criminal charges against a patient or conduct a criminal investigation of a patient unless they have a qualifying court order. They cannot place undercover agents or informants in the program. And actually, this has changed, but a general rule is they can't do it. And they can't use information obtained from undercover agents or informants to investigate or prosecute criminal actions against the patient. And this would be something to explore further in the course about the changes in the law. And we talk about the CARES Act, and they've actually made a couple of small changes to this particular law. Also, the disclosures to criminal justice system that have referred the patient, we get a lot of these referrals, especially in like ASAM level 1 and ASAM level 2 as well, because we have DUI courts and we have drug courts and we have probation officers, and judges will assign people substance abuse evaluations, or sometimes they'll assign treatment, and they want updates. They want to know, has this person started? Have they completed? Are they being compliant? Are they paying their fees? They want to know all of that stuff. But under 42 CFR Part 2, if the patient is referred by the criminal justice system as a condition in their criminal proceeding or their parole or their probation, then the Part 2 program may disclose information about the patient to the individual in the justice system, and specifically the probation officer or whoever the referring person is. As long as the disclosure is limited to that particular person with duty to monitor, and that the patient signs a written consent that satisfies certain elements. So we want to make sure that we're putting the probation officer, parole officer, drug court, case manager, whatever, we want to make sure we're putting their name on the consent. The person in the criminal justice system may only use this and redisclose the information to carry out duties regarding the patient's conditional release or parole. So whether or not they lock them back up. So for use in proceedings, except with a valid court order or patient consent, Part 2 records or testimony about these records cannot be disclosed or used in any civil or criminal or administrative or legislative proceeding conducted by any federal, state, or local authority against a patient, and it includes the record or testimony shall not be entered into evidence in any prosecution, either criminal or civil, before any federal or state court. The record or testimony shall not form part of the record for the decision or otherwise be taken into account in any proceeding before a federal, state, or local agency, and that record or testimony shall not be used by any federal, state, or local law enforcement agency for the purpose for any purpose to conduct any law enforcement investigation. We want to make sure that we're giving written notice upon admission. We want to summarize federal law regarding confidentiality, and that's going to include the limited situations in which we acknowledge that the person is even a patient. we need to let them know that a violation of a law is a crime and get the contact info for making reports to that. We also want to make permissible disclosures to the police, and if there is any child abuse reporting requirements, we need to make sure that we're notifying them that, hey, we did this, or it might not go over so well with the client, and that can also mean not informing certain people that, hey, if you're treating a client, then you have to let the client know, hey, I'm going to make this report about child abuse, but I may not inform the parents at that point. So let's move on to breach notification. There may be a breach. Maybe you sent the email to the wrong person, or maybe somebody hacked your system, or an email was sent out, a mass email was sent out with the client's information, and this would constitute a breach. And this means the acquisition, the access, the use, or disclosure of protected health information in a manner that wasn't permitted under subpart E of that part, which compromises the security or privacy of the protected health information. A breach is going to exclude a few things, and this is going to be any unintentional acquisition or access or use of that protected health information by a workforce member or a person acting under the authority of the covered entity or the business associate. So if such an acquisition, access, or use was made in good faith and within the scope of the authority, and it doesn't result in further use or disclosure in a manner that wasn't permitted under subpart E of part 2, then that is unintentional. Or if there's any inadvertent disclosure by a person who's authorized to access the PHI at a covered entity or business associate to another person that has authorization to access that PHI at the same covered entity or business associate, or an organized healthcare arrangement in which the covered entity participates and the information was received as a result of that disclosure is not further used or disclosed in a manner that's not permitted under subpart E, then that would be unintentional as well. And then a third reason would be if there was a disclosure of PHI where a covered entity or a business associate has a good faith belief that an unauthorized person to whom the disclosure was made would not reasonably have been able to retain such information. So that would be unintentional as well. So a breach is considered discovered as of the first day, which is known to the covered entity, or by which the covered entity would have known had it exercised reasonable diligence. So they have to notify the patient without unreasonable delay and no more than 60 calendar days after the discovery. And notice must be written in plain language and must include a brief description of what happened, including the date of the breach and the date of the discovery of the breach if it's known, and then a description of the types of unsecure protected health information that was involved in the breach, like full name, social security number, date of birth, home address, account number, diagnosis, disability code, etc. And then the steps that the individual needs to take to protect themselves from any potential harm that could result from the breach, and a brief description of the covered entity's actions to investigate the breach, to mitigate any harm to anyone, and to also protect them from further breaches. Also, contact procedures for questions or additional information has to be given in this notice. And they have to notify HHS within 60 days if 500 or more individuals were included in the breach within 60 days of the end of the calendar year for any others. And then they must notify the media also if there's more than 500 people in the state or the jurisdiction that were included in the breach. So we want to make sure that we're preventing multiple enrollments. So we can disclose records to central registries or withdrawal management or treatment programs that are less than 200 miles away to prevent multiple enrollments. And this would be something along the lines of like opioid treatment facilities would specifically utilize this. We want to make sure that the client's not getting, Suboxone over here, and then they're going somewhere else and getting Suboxone somewhere else. We want to make sure that doesn't happen. So we want to have the patient consent that names the registry or programs, except they may generally refer to programs less than 200 miles. So you don't have to be specific there. And then we want to make sure disclosures made when the patient accepted the treatment, if there were any drug changes, any treatment that's interrupted or resumed or terminated, and we want to limit that disclosure to certain information. And this can be a registry or withdrawal program, may communicate with others to avoid those multiple enrollments there.